Hi, everyone. I'm Fran Clark with the CLM, and I'd like to invite you to a special webinar presentation entitled Journey to the Center of the Hellholes. Thank you for joining us today. We're glad you're here. Today's webinar will be a 60-minute presentation with a Q&A. Our presenters will discuss the American Tort Reform Foundation's Judicial Hellholes program, which has been in existence since 2002. Judicial hellholes are places where judges in civil cases systematically apply laws and court procedures in an unfair and unbalanced manner, generally to the disadvantage of defendants. This definition recently has evolved to include law and rulemaking activity, much of which can affect the fairness of any given jurisdiction's civil justice climate and judicial action. And before we begin, just a note about the Q&A. And at any time during today's session you have a question for our presenters, click on the lower portion of the Q&A box that should be showing on the left side of your screen, type in your question and submit it. As mentioned, we'll do our best to answer as many as possible, but you can type a question at any time. Okay, at this point, I'll go ahead and introduce today's presenters. First, I'd like to welcome Ronna Ruppelt. Ronna has spent more than 35 years in the industry, both as a practicing attorney and primarily in claims management and executive roles with a variety of carriers. Her last role was Senior Vice President, General Counsel, and Chief Claims Officer for a regional carrier. This background has built a strong foundation for her current role as Chief Executive Officer of the CLM. Ronna is passionate about serving the vibrant CLM community and advancing claims and litigation management. Hello, Ronna. Next, I'd like to introduce Lauren Jarrell. Lauren is Director and Counsel of Civil Justice Policy for the American Tort Reform Association. She's the lead editor, author of the 2022-23 Judicial Hellholes Report and manages the overall Judicial Hellholes program. Lauren also manages the association's amicus program and oversees the substantive side of the public affairs program. She has been with ATRA since 2012 and is a double Hoya, having graduated from Georgetown University and Georgetown Law. Welcome, Lauren. With those introductions out of the way, I think we're ready to go. I'm going to go ahead and turn the slides over to Ronna. Take it away.
Thank you, Fran. Good morning, everyone, or good afternoon, everyone. Lauren, first of all, I'd like to start out by thanking you for joining us today. We're really lucky to have you and really appreciate it. I hope we provide some insightful information for our audience today. And again, as Fran noted, please feel free to go ahead and ask any questions in the Q&A that should be toward your left. To get us started, Lauren, can you talk a little bit about the American Tort Reform Association and specifically the American Tort Reform Foundation, which is the publisher of the Judicial Hellholes Report?
Yes, thank you, Ronna. I really appreciate the opportunity to be with you today and looking forward to our discussion and our time together. So ATRA is the nation's first and really only national organization that's exclusively dedicated to reforming the civil justice system, mainly at the state level. We work with state legislatures and work to enact reforms. We have a robust amicus program, and then we have a substantive public affairs program as well, which the Judicial Hellholes program is a large part of. And the American Tort Reform Foundation is the educational arm of ATRA. It's responsible for publishing the Judicial Hellholes Report and other legal reports throughout the year.
Great, thank you. And can you talk a little bit about the methodology that is used to comprise these judicial hellholes that we're seeing in front of us right now?
Certainly. So the process really takes place throughout the entire year. Our team does a great job of compiling judicial opinions that are released by both state and federal courts. We do membership outreach and survey our members. We have a broad number of industries that are represented, and so we speak with them. We also reach out to local defense attorneys to hear what they're experiencing and see what's happening on the front lines as well. And we compile all of this information and take a look at which states are the outliers, which courts are allowing novel expansions of liability, allowing novel theories to proceed in their courts, and that's how we begin the process of compiling the report.
Great, thank you. So everyone is looking at the 8 winners or losers, so it be, for the 2022-23 report. And if you take a look at the actual report, I noted that there were 2 topics identified for each of these venues. The first one was attorney advertising spend. And interestingly, I drove from my home in Atlanta up to Northern Virginia over Thanksgiving and really took notice of the attorney billboards that were everywhere. There was one attorney that probably had 50 billboards across multiple states, and in some places not more than a mile apart from each other. So it tells me that from the advertising standpoint, something is working. Can you talk to us in the compilation of the information for this year's report? What did ATRF see on this issue regarding attorney advertising?
So we've seen the spends really increase exponentially over the past decade. These trial lawyers and law firms are spending millions of dollars, specifically in judicial hellholes, where they know that they're going to have success. They're in plaintiff-friendly areas. ATRA releases these trial lawyer advertising reports throughout the year for specific jurisdictions, and we've included some of that data this year in the Hellholes report. And the reason behind this is there's twofold. First, by increasing the number of claimants in class actions, you really increase the pressure on defendants to settle. So they spend thousands or millions of dollars trying to get additional claimants to increase the numbers in their class actions, putting that pressure on defendants. And then they also work hand in hand with the media in peddling junk science out there specifically about medical devices and pharmaceuticals. A recent FDA report showed that these advertisements are having a real effect. People are stopping to take stop taking their medication without consulting their doctors, and then that's leading to strokes, heart attacks, and even death sometimes. So there's a really harmful impact on the audiences that are seeing these advertisements. One thing that is being done is several states are looking to enact legislation to prevent misleading advertisements, to rein in some of the abuses that's being seen in this space, to protect consumers and not allow them to use government agency emblems and things like that to make people feel like there's a sound basis for what they're saying.
Great, thank you. And it's interesting because we received a question asking if it was Morgan & Morgan that was doing the advertising, and that actually was in my notes to comment on that it actually wasn't Morgan & Morgan. So a couple of us probably went right to them, but it actually wasn't them. It was a female solo practitioner. The second item that is highlighted in the report for each of the venues is what is called a tort tax. Can you define this tort tax for the audience, please?
Yes, the tort tax is basically an increase in prices of consumer goods and services that are a result of the increase in litigation costs that are being placed on these companies. And there's never going to, our reports look at the excessive tort tax because it's never going to be zero. There's always going to be litigation costs that play a factor in prices that consumers pay. However, in certain states where they allow abuses of the civil justice system, where they see a lot of high number nuclear verdicts, that tort tax is increasing drastically. And in some states, it's even increasing faster than our inflation rates right now, which obviously is a point of international interest. So over the past few years, we've seen this tort tax increase drastically in our judicial hellholes, and we point that out in our report.
Great, thank you. Before we talk about some of the states specifically, it looked like there were several drivers that were common in those venues that made the list. And I'd like us to start off talking about those major drivers. Let's start out with the one that's on the screen right here, which is nuclear verdicts. And I just want to make sure for the audience's benefit that definitionally, nuclear verdicts are those that exceed $10 million. So we see that in more than half of the venues on the list, nuclear verdicts was one of the reasons. Are we seeing more of them, and are they higher than they have been in the past?
Yes, we are definitely seeing more of them, again, specifically in these hellholes jurisdictions. Part of it is due to an anti-business sentiment, but then other factors include things that are being allowed by the courts. Specifically anchoring, the tactic of anchoring, where plaintiffs' lawyers are allowed to suggest a very large number for mainly driven by non-economic damages, and that becomes the starting point in the juror's mind. And then they usually increase or fall somewhere around that anchor. There are things called phantom damages, the lack of transparency in damages, which we'll talk about more later. But there are some things being allowed by courts that's leading to this increase in number.
Okay, great. And during this study this year, did the ATRF identify certain lines of business where the nuclear verdicts are more prevalent than in others?
Yes, so we're seeing it a lot in the trucking industry. Really target even the small mom and pop trucking companies down south, specifically in states like Georgia and Florida. They're being hit very hard. Also in auto product liability cases, in Georgia, there was a $1.7 billion verdict this year against Ford. In a case, there was another multi-million dollar verdict in Wisconsin against Hyundai. And these judges are allowing in some junk science to help get to that point. And then again, allowing anchoring to lead to a very high starting point.
And is your organization aware of actions that the industry is taking to address these nuclear verdicts? And if so, could you give us some examples of those actions?
Sure. We're looking to work with state civil justice organizations to pass anchoring legislation, which would prevent anchoring from occurring in certain states or in most states. That's one area. We're also looking to increase transparency in damages so that phantom damages aren't able to provide a windfall to plaintiffs. Phantom damages occur when the amount billed for medical expenses is allowed in as opposed to the amount paid, which oftentimes is, maybe 10% of the amount billed. And when you use those medical bills and to multiply by a factor of 3 to 5 to get your non-economic damages, the inflated numbers really have a large impact on the final damage award. We also are looking to undertake a lot of education so that people understand that the impact that this is having on the average American, what it's doing to the tort tax that they're paying and the cost of services and goods, so that they understand that these nuclear verdicts that are being awarded really do have a lasting impact on everyone in the community.
Great, thank you. Let's switch to the second commonality that we saw in many of these jurisdictions, third-party litigation financing. Can you talk about what that is to our audience, please?
Certainly. So there's two different types that we focus on. First, you have the consumer third-party litigation finance, similar to fast cash, where plaintiffs can go and take out a loan to cover expenses while they're waiting a settlement or a verdict. They oftentimes enter into these agreements that charge interest rates that are well above the usual usurious rate. In some instances, it's up to 125% of the loan that they're taking out. And these plaintiffs are required to pay back the full amount of the loan, even if they only receive $1 from their judgment or verdict, which creates a system where sometimes it's more beneficial for the plaintiff to lose the case so that they don't have to repay these loans. But that's one area that's having a large impact on the average consumer. On the other side, we're seeing commercial third-party litigation finance, where funders, hedge funds, investment banks are giving millions of dollars to law firms to fund their litigation, specifically in the mass tort space. And they use that money to then pay for advertising, to pay for expert witnesses, which increases the amount of litigation that these law firms are able to undertake. In both instances, to address these problems, we're looking to require disclosure. As of right now, a plaintiff or a law firm does not have to disclose to the court, a plaintiff doesn't have to tell their lawyer or the defense counsel that there is this third party that has a financial interest in the case and that is really pulling the strings behind the scenes. So we think that disclosure would go a long way, and that as all of the parties involved should be aware of this interest. And then on the consumer side, we're also looking to enact legislation that would cap the interest rates that they can charge, which really would get to the crux of their business model. If they're not able to charge these absorbent interest rates, then it would harm their predatory practices and hopefully put an end to some of the abuses that we're seeing.
Do we think that we're going to be seeing more and more bills introduced on these two areas in the current session for the states?
I do. And also I should mention that Congress is looking to do something as well. Several federal courts have adopted rules requiring certain levels of disclosure, and there's a strong business community effort underway to urge Congress to take similar steps. I will also say that on the consumer space, the lenders themselves are pushing bills. That can often seem like a good thing, that they're attempting to regulate themselves. However, if you look closely at their bills, it's often a lot of tough language, looking at size of contract words and bold fonts and text and things like that. However, the one important thing that those bills are lacking is that cap on the interest rate. And several states do not apply their state usury laws to these loans because they're non-recourse in nature, which means they only have to be paid if the plaintiff is successful at court. And so because of that non-recourse function, the state usury laws don't apply. And so as of right now, there are no caps on those interest rates.
Okay, great. Thank you. Before we move ahead to no injury litigation, I did want to ask one follow-up question. Can you define what anchoring is? It seems as there's members of our audience that aren't fully familiar with that term. Can you hear me? It looks like Lauren got disconnected. We'll have to bear with her for 1 minute, and she can get back in. While we're waiting for Lauren, I'm looking through some of the questions, and someone asked a question about, I thought it was illegal for plaintiff attorneys to reach out to individuals after accidents. Major advertising doesn't fall under that is the question. And the answer is, unfortunately, it doesn't. I know that many years ago, advertising was very, very restricted. You were not able to talk about specific awards. Because it would be used as an example of, I got this for this person, can get it for you down the road. There were some First Amendment challenges that were made, and as a result of that, attorney advertising is pretty much an open door right now. I think that would be up to various state bar associations and Supreme Courts, whoever is managing the attorney ethics in that particular state, to put any modifications, but again, it would have to come within those restrictions of free speech could not occur. So, Lauren, you're back with us. If you
Apologies.
That's quite all right. Technology, every once in a while, things don't work great. Can you talk about anchoring, explain that concept for our audience, please?
Certainly. So in anchoring, at the end of trial, the plaintiff's lawyer is allowed to suggest an award that they think is fair for their client to receive. And they often ask for a very large number. There's been psychological studies done that show that once that number is suggested, that then becomes the starting point in the juror's mind. So they are allowed to start at a much higher point that really has no foundation in the facts, but they just throw it out there so that that's where the jurors are starting their deliberations and their conversations.
Great, thank you. And another question was raised, and I could comment on it, and Lauren, you may be able to comment on it also. But a question was asked whether insurance carriers have the ability in some states to counter the plaintiff firm advertising with their own advertising. And I'll start out with a comment on that, and if there's anything you want to add, Lauren, that would be great. One of the things that the industry is bound by that does not impact the plaintiffs and puts us a little bit at a disadvantage from an insurance industry standpoint in our antitrust rules. So there cannot be coordination on practices that occur among insurance companies, especially those that may go to pricing or competition. So it's difficult, very difficult to have any type of coordinated effort in that regard between carriers. However, there are industry organizations such as ATRA, the Chamber of Commerce, the Insurance Information Institute, III, and other similar organizations that have kicked off public awareness campaigns and are going to be doing more and more of that public awareness to make sure that the public knows that they ultimately are the ones that fund all of these nuclear verdicts. Lauren, is there anything that you're aware of that you'd like to add to that comment?
I would just say that a lot of the advertising that we're seeing, too, is not done by the law firms themselves, but it's done by aggregators. And so they're able to get around some of the laws that are on the books. They put out these advertisements, they pull all the classes together, the class members, and then sell those to the law firms. So that's been one way that the law firms have gotten away around some of these, not restrictions, but regulations that are on the books. And also, I heard your conversation a little bit about the First Amendment concerns, and that certainly has been a challenge. And that's why many of these bills are focusing on medical devices and pharmaceuticals and looking at the public safety angle because, for example, the recent Fourth Circuit decision over the West Virginia's law, they found that there was a real public interest in preventing misleading advertisements in that space because of the public health concerns.
Great, thank you. Let's talk about the third component that is common in most of these judicial hellholes, and that's no injury litigation. Can you start out by explaining to the audience what ATRF means by no injury litigation?
Certainly. So, when I was in law school, when you start out, one of the basic tenets of a tort action is that the plaintiff or the party was actually injured, that they suffered some harm, whether it be economic harm, physical harm. What we're seeing with no injury litigation is that the plaintiffs and class members didn't suffer any injury. There's no harm. Maybe there was a technical violation of a statute, or in the food and beverage space, for example, the Slackville lawsuits. The potato chip bag has extra air in it, and they feel like that's slack that they didn't need to pay for. And so these no injury lawsuits are being allowed to proceed with the plaintiffs having no injury. And Jones Day recently did a study that found that the real beneficiaries of this no injury litigation are the class lawyers. The class members receive pennies on the dollar while the lawyers are taking home millions of dollars. And so they have a real interest in pursuing no injury litigation for that reason. A couple of the areas that we highlighted in the report specifically, in Illinois, there's something called the Biometric Information Privacy Act, which we'll discuss when we get to Illinois. But basically, any nitpick technical statutory violation can lead to thousands and thousands of dollars in fees and fines for the company. As I mentioned, food and beverage. There's someone in New York pursuing all of these vanilla lawsuits, that doesn't contain real vanilla, it's vanilla flavoring, or the slack-filled food and beverage cases as well. And we're also seeing it in Americans with Disabilities Act litigation, where you have these serial plaintiffs that are visiting establishments for the sole reason of saying that they don't have everything up to code. They really have no intention of going there or, engaging in any sort of business relationship, but they're just going to find an ADA violation.
I've actually heard in California that there's firms that use drones to go over hotel swimming pools to make sure that they have the appropriate accessibility for the getting into the pool, the right equipment. Yeah. It's pretty amazing when you think of it.
They've undertaken some really interesting strategies.
Very creative, that's for sure.
Very.
So let me ask you this question that came from one of our audience members. When a list like this is published and it's available to everyone, does this become the roadmap or a cheat sheet for plaintiff firms, plaintiff attorneys of what venues they need to go to file their litigation?
I don't think we're necessarily saying anything the plaintiff's lawyers don't already know. We're highlighting the abuses that are allowing, and the point of the report is really to be a catalyst for change. We've seen it be used very effectively in some of the hellholes to urge state leadership to make changes, to make reforms because they don't want to be on this list. I don't think we've heard about it being used the other way. That's not to say that it hasn't happened, but we also are looking to see where the most activity, where the trial bar is focusing their attention. And that's borne out in these states. So again, that's something the trial bar knows, that these are the areas where they can go. They have low barriers of entry, low expert evidence standards, and that's why we're seeing an increase in filings or an increase in advertising.
Okay, great. We did receive a couple of questions, and I'm going to just touch on one or two, and then we'll need to move forward and talk about the specific states. In your analysis, are you seeing plaintiffs in the food and beverage, no injury space, individual plaintiffs, or is it primarily class actions in that space?
It's primarily class actions, almost exclusively. New York and California and Illinois are the top three for food and beverage litigation. And it's typically one or two law firms. There's someone named Spencer Sheehan in New York he's known as the Vanilla Vigilante. And he's been putting together all of these class actions targeting ice cream makers and beverage companies pursuing this litigation on behalf of these classes.
Okay, great. All right, we're going to move ahead now, and we're going to talk about the states. We don't have a lot of time. We could spend all day spending a lot of time on each of these states, but we're going to touch on a couple of key points with each of these states. As someone who lives in Georgia, I was not surprised at all to see the #1 ranking. But what was it this year? What drove Georgia to win or lose this ranking? So Georgia's civil justice system has been deteriorating over the past several years. It's been on the list for the probably past 2 or 3 years, and it's definitely been going down a concerning path. However, this year, with that $1.7 billion verdict against Ford in a rollover case, it really reached fever pitch. The facts of that case and what was allowed to happen at the trial court level was very concerning.
Georgia's a state that has a seatbelt gag rule, so the jury wasn't allowed to hear that the passengers in the car were wearing their seatbelts incorrectly. There was a lot of shady ethical questions, and the judge involved in the case has very close ties to the trial bar as well. So that really propelled it to the top. Last year, we simply put a spotlight on the Georgia Supreme Court, but this year we felt like we needed to expand it to the whole state because the Georgia Supreme Court has a propensity to expand liability. However, the court sees itself as a very originalist court, textualist, so it sticks to what is written on the page, and that's it. And they've continuously sort of punted certain issues to the legislature and said, oh, if you want this changed, the Georgia legislature needs to do this or it needs to do that. And the legislature has been responsive to a degree, but not to the level that it needs to be addressing the abuses that are occurring in the state. So that's why we expanded it to the full state this year as opposed to only focusing on the Supreme Court.
Okay, great. Thank you. And I did want to mention to everyone that there is a link to the full Judicial Hellholes report. I believe it is on your left side of the website, so you can follow along. And the link is to the full website where it talks about it's interactive, and it talks about everything we're going to be talking about in a lot more detail. So I just wanted to make sure everyone was aware of that. Let's talk about our second. Give me 1 second, please. There we go. Our third, bear with me here. There we go. That's what I was looking for, was good old Pennsylvania. And I know the report, again, specifically references the Pennsylvania Supreme Court and the Philadelphia Court of Common Pleas, which is the trial level court in Philadelphia. What has driven this? I know they've been up there for a while, but what has driven these courts to number 2?
The Pennsylvania Supreme Court has been very hesitant and to much degree refused to apply U.S. Supreme Court precedent around personal jurisdiction and when out-of-state plaintiffs are allowed to file in state court. It was the Bristol-Myers Squibb decision from 6 or 7 years ago. And so they had this open door policy to claims from all over the country. And the Philadelphia Court of Common Pleas has become just a mass tort hotspot. Everyone's filing their mass tort claims in that court because of plaintiff-friendly judges, low evidentiary standards, and there's also some friendly juries there as well. And so we've seen, I believe, in nuclear verdicts, they were in the top 3. The U.S. Chamber released a study that looked at the nuclear verdicts total number from 2010 to 2019, and Pennsylvania was in the top 3, and 60% of the state's nuclear verdicts came out of the Philadelphia Court of Common Pleas. And so that is where the plaintiff's lawyers want to bring their lawsuits. This past year, the Pennsylvania Supreme Court unilaterally eliminated the state's medical venue rule, a rule that was adopted in 2002 to address the healthcare crisis in the state. It had done a great job. Premiums were going down. Doctors were coming back into the state, and the healthcare system was moving in the right direction. And now they've eliminated that, and this will allow plaintiff lawyers to file medical malpractice cases basically in the most plaintiff-friendly court of their choosing because of the new relaxed standards. And so that was very disappointing to see and is of concern now that it's going to lead to another healthcare crisis, particularly in the rural areas.
Okay, great. Thank you. All right, let's move on to California. California was number 1 in the last report. It slid down 2 slots to number 3, and it looked like, based on my interpretation or reading, is that it really wasn't that California got better, but it's that Georgia and Pennsylvania got worse. The report cites the 5 primary reasons that are listed on this slide. And it does look like, and has always been like this, but maybe more so, that California is a hotbed for those no injury lawsuits that you were talking about. Can you talk to us about anything important with regard to any of these 5 issues that drove California to be number 3 that we haven't already touched on?
Yeah, I think the interesting fact about California is they actually embrace their hellhole status, which is I can't say that we find that in all the other states, but they embrace the status. It just doesn't really bother them. But I think something important there is that California is the plaintiff's bar's laboratory. They bring every new novel theory of liability that they're thinking about, and they try it in the California courts. And if they get success, which unfortunately most often courts do allow these novel theories to go on, then they export it to the rest of the country. So when we're talking with states, we tell them to look to what's happening in California, because if it is getting oxygen and is being allowed to happen, to continue, then it most likely will pop up in other states, particularly other hellholes across the country. So I think they're on the cutting edge, unfortunately, of many of these litigation issues.
Okay. Yeah, it was interesting to see the London law cases as something that's such a big deal there, because you see them, but I was surprised that they're so compelling. And I know the proposition process in California is somewhat unique. It's the ability to get something on a ballot relatively easy and voted on by the populace. And I know over the years, the various propositions have driven a lot of interesting and novel theories and litigation for many, many years. Can you just real quickly talk about what the Proposition 65 lawsuits are?
Sure. So Proposition 65 is the requirement that companies have to label their products as known to cause cancer or known to cause some sort of health issue. There's over 1,000 chemicals that are now, and substances that are now on this list. And it's gotten to the point where there's so many things on the list, and it's so controversial, the studies that they use to link these items to cancer, that they're almost having the opposite effect, that consumers aren't really listening to them anymore. But the Prop 65 lawsuits have really focused on Roundup, the herbicide Roundup, and the glyphosate that's in there. That's a Prop 65, that's on the Prop 65 list. However, and this is a perfect example, there's only been, out of over 800 studies conducted by agencies all around the world, only one study, the IARC study, International Agency, IARC, they're the only ones that have found a linkage to cancer. And their report also had tiebacks to the trial bar as well. And so, unfortunately, California courts have allowed that to be a basis for finding liability and for allowing that litigation to proceed. But we're seeing that with other things as well. There's some coffee litigation that worked its way through the courts, talc litigation. They just allow these questionable scientific studies to be the foundation for the litigation.
Okay, great. Thank you so much. And we're going to move ahead to the next state, and I know there's a lot of questions. I want to get through the states and hopefully save enough time that we can answer some of the questions, but we have quite a few. So New York is number 4, and the list of the drivers for that ranking is on the slide that everyone can see. With regard to this particular list, is there one individual component, one driver that might have more weight than the other drivers?
I think it's the nuclear verdicts here. New York previously had a de facto cap of $10 million on non-economic damages, and that had been the case for decades. Over the past few years, and actually this past year was the first year that an appellate court upheld a non-economic damages award well past that $10 million. And so we're seeing that cap be almost taken off the books. It was never on the books, but it's no longer the de facto cap. And this is a state that allows anchoring, and that has had a real impact. And so I would say that the nuclear verdicts has really, elevated New York's status. And again, they've dropped from the list. They were previously number 2 to California. Their fall is, again, a no reflection of improvements made in the state, but just simply the issues in Georgia and Pennsylvania were too hard to ignore.
Okay, great. Thank you. Number 5 is Cook County, Illinois. I know for many years, Madison County was up there, but it's been replaced by Cook County, which is the Chicago metropolitan area. And I know you mentioned the biometric privacy law. Can you talk a little bit more about that in some detail? Because I sense that's probably a significant driver of their ranking right now.
Yes, it is. And I will say Madison County and St. Clair County are still included in this year's report. They simply they're the asbestos destination. And so we focus on that in the dishonorable mention. But Cook County has a plethora of issues, which we've laid out on the screen. And so we felt like it was really important to focus specifically on Cook County. And yes, the Biometric Information Privacy Act lawsuits, and specifically the no injury angle to those lawsuits, is a real concern. And basically, this act created a private right of action for the incorrect use of a person's biometric information, whether it be scans, fingerprints, any of that information. If it's wrongly disseminated or sold or collected in some way, then there can be litigation around that. And 2 or 3 years ago, in a case involving Six Flags, the Illinois Supreme Court said that the plaintiff did not need to suffer any injury in order to bring a lawsuit. And this opened the floodgates. All they needed to do was allege a statutory violation, and they could collect. And there was grounds for a lawsuit standing. And so this was, like I said, opened the floodgates to litigation in the state. I think the number of lawsuits has increased almost 80% over the past few years. And there are a few important cases that are currently pending in front of the Illinois Supreme Court that are going to continue to shape this landscape. The court's deciding which statute of limitations should apply in this litigation, whether it's 2 years or 3 years. So that will open the window. And then they're also deciding whether claims accrue each time a business scans a person or transmits it to an outside company, or just on the first time. And so if they go with each time, that is going to send these fines into the millions of dollars. Also this year in 2022, the Illinois Supreme Court held that these types of lawsuits are not compensable under workers' comp. So the state's workers' comp laws don't apply to employees that have suffered or has seen a violation. So that also will have a big impact on future litigation.
Great. Thank you, Lauren. Let's talk about number 6. And interestingly, I know there's a big red zone in South Carolina just from personal experience, but I was interested to see that the report identified the asbestos litigation specifically. I actually have thought, somewhat naively, that asbestos is kind of on the way out, but it's sounding like it isn't this year. I know it's been around for as long as I've been practicing, which is well over 30 years. So it seems like it's going to be around for a long time. Talk to us a little bit about, this Texas law firm that's listed on the slide and the asbestos litigation that we're seeing in South Carolina specifically.
We're seeing, the Dean Omar firm out of Texas is one of the most active asbestos litigation firms in the country. And they try cases, or they attempt to try cases all around the country. And they've received some pushback in some states, haven't had the success, but unfortunately, Judge Janine Toll in South Carolina is rubber stamping a lot of their their cases, whether it be motions for sanction or evidentiary questions. They're getting very favorable rulings from her, so they continue to flood her docket with litigation. And we're seeing in the take-home exposure cases, an employee brings it home and their spouse now gets mesothelioma from being exposed to asbestos fibers on clothes, or they're going after new businesses that have not filed bankruptcy to find the deep pockets. And so that's what we're seeing in South Carolina. And unfortunately, Judge Toll has a lot of influence in the state. She was previously a South Carolina Supreme Court justice. And so this past year, we saw the appellate court, as opposed to push back on some of her more abusive rulings, they rubber stamped them and have allowed them to stand. And that was really disappointing this year, and was a bit of a surprise that was highlighted in the report.
Okay, great. Thank you. Number 7 is Louisiana. Not surprising. It's been a hotbed of fraud for as long as I've been in this industry. Let's talk about the staged accidents. Are we seeing more of them in Louisiana than other jurisdictions, and also more than we were seeing in the past?
So we want to praise the Louisiana court for going after this fraud and bringing it to light, because they have undertaken this investigation for the past several years, and they've done a great job bringing the wrongdoers, to justice. But it was their civil justice system and the abuses that were allowed to occur that allowed this level of fraud and staged accidents to occur in the first place. And so we have seen these types of schemes in other states. There was something similar with litigation financing and medical doctors in New York. I think that when you have these civil justice systems that are broken, then it just breeds fraud and things like this. And so, unfortunately, we haven't heard any. The stage accidents that were highlighted was part of a scheme that happened a few years ago. They just continue to bring more of the facts to light, and we want to continue to put a spotlight on what was allowed to occur and give updates.
Great, thank you. And our last jurisdiction on the list is St. Louis. I know that bill versus paid was supposed to have been addressed by legislation that was passed in 2017, but it looks like we're still seeing this issue out there. What's going on with that? And also, if you could explain to the audience what we mean by bill versus paid. I should have started out.
So for billed versus paid, when anyone goes to the hospital, you have the amount billed, which is much higher than the amount ultimately paid, because you have these negotiated rates, whether it be between your private insurance carrier, Medicare, Medicaid. In the end, the negotiated rate is what is actually paid. But when you only allow in evidence of the amount billed, it creates this windfall of money that was never exchanged hands. It was the plaintiff didn't. That's not a cost to the plaintiff. And so, yes, they addressed this back in 2017, but unfortunately in recent year, or 2017, excuse me, but in recent years, Missouri courts have now allowed the amount billed to come into the evidence for another purpose. They're allowed to use it to show the severity of injuries rather than the amount sought to be compensated. And that was something that was allowed in the language of the statute. And so they're now using that loophole to get this evidence in. And as a result, it's artificially increasing damage awards. It's delaying settlements and then ultimately increasing insurance premiums across the board. And this is part of a broader theme that we're seeing in St. Louis, because the Missouri legislature in recent years has enacted some positive reforms and has done a great job, but there's a real hesitancy by the courts in St. Louis to apply these new reforms, specifically in this space, and also with expert evidence in the Daubert standard that was enacted in 2017 as well.
Okay, great. Thank you so much. So these are the 8 jurisdictions that have made the list this year, and there are several questions about Texas. Texas seems to be conspicuously absent for some of our audience members. Can you talk to us why isn't Texas on this list this year?
So we do have the Dallas Appellate Court, the 5th District Court, on the watch list. And we have paid close attention to this court in particular over the past 2 years. It has been overturned by the Supreme Court on civil justice cases several times over the past year. It's a very plaintiff-friendly court. And so we're going to continue to keep an eye on it. It may be elevated in the future. In one particular instance, they refused to adopt the Apex Doctrine, which only allows an executive of a company to be deposed in very limited situations. So we're looking at that court, paying attention to their plaintiff-friendly rulings, and we'll see where they decide to go.
Okay, and that's actually a precursor to the next slide. We have a lot of questions, and I'd like to go through some of those. So I just want to go through the next couple of slides very, very quickly. But this is the watch list. There's Texas for everyone. If you could, again, I know we're getting several questions. Can you give us the URL for the website? And everyone in the audience should also know, in addition to the interactive website, I think it's about an 86-page report. It's very, very detailed, talks very specifically about a lot of the topics that Lauren touched on today. And this is something published every year in December. I've been anxiously awaiting it every year for years and years. So now for those of you that were familiar with it, you'll look for it every December. But what's the URL for the website?
Certainly, it's judicialhellholes.org. And now through the end of February, when you go to that page, it will take you to the interactive executive summary for the report. And then from February until December 2023, it becomes a blog where we post blog postings, updating on different cases, updating on what's happening in the hellholes. So it will provide new news for everyone to follow along with throughout the year, leading up to our 2023 release in December.
Great, thank you. So this is, again, the watch list, which is also detailed in the report. This is a couple comments on dishonorable mentions that is also detailed. I would highly encourage, especially for the lawyers that are on the call, the ALI restatement has been a very big issue. I think people know that historically that was more treatise work, and unfortunately there are some courts out there that are adopting this treatise-type work. They've expanded some of the theories inconsistent with case law, and judges are adapting that expanded without any basis, without any legal precedent. So I'd encourage you to take a look at the report for all of these issues, and then touch on the points of light, and then we'll get to some questions. Lauren, on this slide, is there anything specifically that jumps out at you as a positive point of light that you'd like to highlight before we move to the questions?
I would just like to highlight the Florida Supreme Court. I think there's a lot of great things happening with that court in particular under Ron DeSantis' leadership. The Florida Supreme Court was the #1 hellhole probably 5 or 6 years ago. So they've really undertaken great change. We still have work to do with the Florida legislature, but at least now we're starting to get well-balanced decisions by the high courts in the state.
Okay, great. Thank you. So let's move on to some of the questions. And some of this does jump back to some of the earlier topics. Lauren, are you able to provide us with some examples of the junk science that judges are allowing into evidence?
I think the IARC report in the Roundup litigation is one example. That was allowed in St. Louis as well. You're also seeing it in the talc litigation. The American Cancer Society said it's certainly not, it hasn't been confirmed that talc causes cancer, but these plaintiffs' lawyers are allowed to bring in expert witnesses that say otherwise. In our report, we highlight some of the questionable backgrounds of these witnesses that have been allowed to testify, and also their ties to the plaintiff's bar. And so I think that's a real concern.
Great. In preparing the report and in your investigations, has ATRF looked at the jurisdictions and done an assessment of where the judges are appointed versus where they're elected? And is there any commonality between that selection or voting process that you're seeing?
So we haven't gotten into it in too many places. However, in Georgia, for example, in the Ford case, the plaintiff's lawyer that was involved in the $1.7 billion verdict was a campaign or contributed to the campaign of the judge overseeing the case. And so we certainly highlighted that in the report, where those campaign contributions exist, and where they're, the spending of the trial bar, if they're putting a lot of money behind certain candidates, we will highlight that, yes.
Okay, great. And I did see that in the report. We have a question about the litigation financing. How do state usury laws impact disclosures from the third-party finance organizations?
So unfortunately, in many states, the state usury laws aren't applying because of the non-recourse feature of these loans, and so that's why entirely new legislation has to be enacted. But that is one of the things that we're pushing for disclosure is, you have to disclose if there's insurance policy involved. So why shouldn't you have to disclose if there is a loan involved? That's one of the arguments in favor of disclosure. But like I said, unfortunately, state usury laws aren't applying in most states.
Great. And there was a question about when you were talking about that the attorney advertising doesn't always come from individual firms, but comes from aggregators. Can you explain what you mean by that, please?
Sure. So aggregators, now I will say Morgan & Morgan and some of those law firms obviously do their own advertising. We see it all over the place. However, in a lot of these instances around the litigation, like advertising for Roundup litigation or talc, they use these companies called aggregators where they're not lawyers, they're not law firms. They put out these advertisements. They pull together all of these potential class members and then sell those class members' information to law firms to then follow up and file litigation on their behalf.
Okay, great, thank you. A question about the maritime industry and nuclear verdicts. Did your analysis see anything there?
Not this year. No, we didn't focus very much on that particular area law.
Okay. We did get one question, and I can answer this one, about why nuclear verdict has a trademark in the slide. It actually has a register mark, not a trademark, and that's because that is a term that initially was trademarked but now is registered by a law firm in California, Tyson and Mendez. So I know that in a lot of the public awareness campaigns by organizations such as ATRA, the Chamber, and some of the other organizations that I referenced earlier, Insurance Information Institute, for example, they're using terminology like social inflation or legal system abuse because the term nuclear verdict is actually a registered term and really should not be used without permission of that firm that did the registration. Question, and I'm not familiar with what this is, but I will ask you the question. In New York, there is something called the Grieving Families Act, and do you believe that that had an impact on the ranking if the governor signs it?
Yes, absolutely, and the report does discuss it. This is a wrongful death statute that will allow several different additional family members to file wrongful death litigation, increases damage awards. So yes, that was a real concern. I think we see the New York Assembly and New York Legislature, unfortunately, look to adopt or enact additional legislation like this, but that is certainly covered in the report and was something we considered.
Okay. And I think we have time for about one more question. I know Washington is not on the watch list, but is it on the secondary watch list?
It is. We work closely with the Washington group on the ground out there, and we have been paying attention. I believe last year, the year before, they had a dishonorable mention out of their state Supreme Court. A lot of concerning bills get introduced by the legislature, but the defensive efforts have been successful this far, kind of keeping them off the list, but we continue to pay close attention to what's going on out there.
Great, thank you. I wanted to make one comment, and I'm going to hand it back over to Fran. But first, Lauren, I would like to thank you so much. This has been very, very informative. By the number of comments, I think people really learned a lot and heard a lot, so I want to thank you. I also want to let everyone know that CE is not being offered for this. It was not in any of our materials that it was going to be offered. So I hope people found it beneficial even without the CE. And with that, Fran, I'll hand it back to you.
All right. Thanks, Ronna. Unfortunately, we have run out of time today. I'd like to thank Ronna and Lauren for putting together today's presentation. Topics like these and many more related to claims and litigation will be front of mind at CLM's upcoming annual conference in March. Go to theclm.org to learn more or register. And I'd like to remind everyone that you can always review past CLM webinars, including this one, by logging into your CLM account and clicking on the Events tab. For the CLM, I'm Fran Clark. Thank you for attending. We'll see you next time.
Bye-bye.